All right, we now are moving on to notes number 5, more real estate concepts. Just a word before we begin and get into this. This is theoretically the most difficult part of the entire course. So if you can make it through this lecture with me and through the notes and through the online meeting that we have, then everything else after this will be simple by comparison. What we're going to talk about here is some of the old rules about property ownership that come down to us from medieval England. And they're not things that you'd actually see every day in the law practice at this point in time. And I'm sure many of the younger attorneys deal in real estate law, many paralegals deal in real estate law, and they rarely, if ever, come across these concepts, but they still exist. They still are the basis for what we're doing in real estate law. And because of that, I feel remiss if I didn't at least go over them with you, give you some notes so that you've got some reference in the back of your head and in your notebook somewhere that if one of these things come up, you can go, oh, I remember 10 years ago, Professor Walsh talked about one of those. All right, we've discussed ownership of property, and one of the things that I like to say is that ownership is the idea of who does the law recognize as having rights in and to the property. Now, rights in the property can mean many different things. It can be the right to use it, it can be the right to possess it, the right to sell it, the right to take it apart, to put it back together, to remove things from it, to attach things to it. If you think of it, there are a huge number of rights that can attach to a piece of property, and particularly when we start dealing with real estate. I like to think of real estate and have you think of real estate in terms of a child's game that we used to play when I was young, and even when my children were young. You folks may not have heard of it, but I'll try to describe it to you the best I can. There is there was an old game called Pickup Sticks, and the way the game began, there were a whole series of sticks that are about 8 or 9 inches long, various colors, and you would hold them all in your hand at one time, and then you would drop them, and the goal was to stop picking up sticks without disturbing any of the sticks underneath or next to the one you're trying to pick up. If you disturbed a stick, your turn was over. And at the end, whoever was able to pick up the most sticks was the winner of the game. The part of the game that intrigues me and that I find applies to real estate law is the idea that owning a piece of land is like having a handful of sticks. There are many, many, many different rights that are associated with it. Now, in the game of pickup sticks, every stick, they were actually rather quite thin. They were only a little bit thicker than toothpicks. But in law, some of those rights are huge. They're very big. Some are very small. But without any doubt, there are multiple rights that are attached to any piece of property. So one of the things as lawyers, when we're conducting real estate transactions, is we have to determine who is holding those rights. And in particular, if we have a client who's attempting to buy a piece of property, to become the owner of a piece of property, we have to determine, does the person telling us they can sell the property to us, do they hold the right to sell? Do they hold the other rights? Because one of the things about real estate law in particular that is a little bit easier than when we're dealing with personal property is that these rights can be spread out to a number of different people. So you can give various rights in a piece of land to a number of different people. Um, and that creates issues. It's one of the reasons why we have a title examination performed whenever one of our clients is going to buy a piece of land, or one of the lenders we represent is going to loan money and take back a mortgage as collateral for the piece of land. We want a title examination done because we want to determine where are those rights, who holds on to them. And again, the person who's entering into the transaction with our client, do they really have those rights? Do they really hold on to them, and do they have the power to give them to our client? Um, we will talk more about this, and I'll keep referring back to this idea of the rights being handed out. But for the time being, think of it as owning real estate is holding in your hand a bunch of rights. Almost think of it as holding a bunch of pencils. If you went to the pencil shop at a sharpen 6 or 7 pencils at a time. You might walk back holding them all in your hand. And you can take those pencils out and you can hand them to different people, or you can hold on to them to use them yourself, or you can put them away in a closet, in the desk drawer. There's a number of different things you can do. And I want you to begin thinking about real estate rights in that way. Now, again, going back to a couple of weeks ago, real estate is land, any interest in the land, anything permanently attached to the land. So the things that I'm talking about here, they apply to fixtures, which we talked about in a prior session. They deal with mineral rights, easements, all types of other things that we're going to talk about as the semester goes on. Now, for better or worse, our real estate law comes to us from medieval England. And one of the things we have to do to understand how all this works is to put ourselves back into the mindset of how people thought about things in medieval England and what the law was like, what the society was like. The theory in England, in English law and history, was that the king owned everything. The king was the sovereign, the king was the ruler. Everything in the country theoretically belonged to the king. Now, the Middle Ages were violent. They were constant disruptions, constant invasions by armies, by raiders, by pirates, by all kinds of things to disrupt society. So a king did not remain king very long unless he had a group of people who would basically protect him, support him, fight for him, act as his army and his bodyguard and his militia all in one. And of course, these people, if we think of it today, they were called knights. They had special status within English society, and they did not give their services to the king for free. So what developed through the 600s and 700s and 800s is the idea that if you loyally served the king, if you were courageous in battle, you slew the king's enemies, you protected the king's life, the king would reward you by giving you a piece of land, a piece of the king's possessions, the king's ownership, which was the whole country. Now, land in medieval England was the most important property that you could own. It was the most valuable property. Today, when you think of all the different personal properties, when you think of intellectual property, when you think of intangible property, stocks and bonds and money, when you think of contract rights, I would venture to say that the value in our economy, the far greater portion of it is in personal property, but in the Middle Ages that was not so. The land was your survival. Everything you needed to live on had to come from the land, and if you had no land, you would very quickly die hungry in the cold. So land was an important reality, and giving the land, and initially the kings would give the land. It was called a fief. They would give a fief to knights who would serve them, but initially it was kind of that the king could give it and take it back. That the king could give it, and when the knight died, his family was thrown off the land, the king could give it to somebody else. Now, if you are a person, particularly a person with a family, one of the things you might want is that once the king gives you land, you might want it to be permanent. And number two, you might want to ensure that your children will have something to live on after you are gone. And remember, the Middle Ages, people died young and often. Very few people lived to see their children grow into middle age. So a couple of things began to happen. The first thing was that over a number of years, the knights began to wrestle from the kings the idea that the land could be inherited. So that when the king gave a piece of land to a knight, he was giving it not only to that man who had courageously fought in battle for him, but that when that man died, it would pass to his children. His widow would have a certain share of it, and that his bloodline, his family would be assured they wouldn't be thrown out again into the dark and the cold and hungry and naked in the night in the Middle Ages. So that was the first thing. One of the first big rights that they kind of wrestled away from the king, and this kind of bargain and back and forth of, well, you want us to support you, Your Highness, here's what you need to do. The second great right that they little by little wrestled away from the kings was the right to sell or transfer the land to someone else. And for many years, maybe even centuries, that was not something you could do. If the king gave the land to you and to your heirs, to your children and their children, that's where it stayed, and it could not be changed until if your bloodline died out and you had no more children, then the king could take the land back and give it to somebody else. But as long as there were children, you could not alienate the land. You couldn't give it to someone, you couldn't sell it. That began to change in the 1100s, 1200s. The English knights went off to war. They went off to the Crusades in the Middle East. They began to realize there were finer things in life like spices and silks and wine and fine women, all things that they didn't have in England. And they also realized the only way to obtain these things was if you had money. What was the only thing they had to sell? The only thing they had to sell was the land. At the same time in England, there was a group of people arising, merchants, people who were cobblers, butchers, masons, builders. Think of all the different jobs and trades that would exist in a society. As these people began to develop, they could earn money, but unless they were born into it, they had no power to own land. And one of the things they desperately wanted was land. So little by little, the knights wanted the ability to sell land, to get money, to buy the finer things in life. And you had a middle class, a trading class growing up that wanted to own land because it gave them stability and respectability that they wouldn't otherwise have. So over, again, a period of centuries, the second great right that they wrestled away from the kings was the right to sell a piece of property to a third party or to transfer it to a third party, not one of your relatives. Today, we call the greatest rights in property, we call that a fee simple still, basically coming from that word fief. And in order to have a fee simple, when we're doing a title exam, we're looking for two big things. We're looking for the right of inheritance, and that right of inheritance can go on forever. As long as you have heirs, then somebody could inherit the property. And we're looking for the right to transfer or convey. If those two rights are held by the person who's the present owner or claims to be the present owner, then we generally say they have ownership. They may have taken all kinds of other rights and traded them away, given them away, assigned them to other people. We can deal with that. But if they don't have the right of inheritance and they don't have the right to sell to third parties, we'd basically say they have something less than full ownership, and the title would not be in our modern terms. We're always looking for marketable title, which means a title that is reasonably free and clear from doubts and problems and issues, and again, gives whoever takes possession, takes ownership, the power to convey it, to let this property go to their heirs, or to take it and transfer and sell it to a third party. Now, having said that, some of the things, if we're looking at the handout 5, the English broke down estates into two categories. One was a freehold, and today we call that a fee simple, and could be a life estate. And it basically means in that situation that you had a piece of property where the king could not take the rights back. So in a freehold situation, the king has given up his ownership in such a way that you and your family, whoever you sell it to, will keep that ownership, and apart from being adjudicated a criminal or something, you're not going to lose that right. Non-freehold estates are estates where you may have at the moment the right to possess and use the property, but at some point your possession will end, or there is some possibility that it can be taken back and that it might be terminated. And these are estates for years, which today we call a lease, a periodic estate, which means it's an estate for a set period of time, which again today would be a rental agreement or a lease. An estate at will, which is the parties agree, I'm going to occupy this as long as you as the owner agree that I can. As soon as either of us decide we're not going to continue with the arrangement, we can end the arrangement. At-will situations exist in tenancies still today. Many tenancies, particularly in some of the older sections of the Northeast, have no written agreements. People just pay month to month, and their tenancies at will. On a month's notice, the tenant can end the relationship, or the landlord can end the relationship. We'll talk more about that when we get into landlord-tenant law. Um, some of these, and some can be what's called an estate at sufferance, where you're presently on the property, you have no particular right to be there, but nobody has taken the action to put you out yet. And again, we get into landlord-tenant law, we're going to find out that under modern legislation, a landlord cannot personally, forcibly remove a tenant, even a tenant who hasn't paid rent for months or years. They must go through the court process. Now, the minute the tenant breaks the lease or breaks the rental agreement by not paying, they're technically no longer a tenant because they've broken the agreement. They are now a tenant at sufferance. But they have the right to stay there until the landlord obtains a court order evicting them, and the sheriff comes to tell them they must leave. An estate for years would be today what we call a life estate. I'm sorry, what we call a lease. Where do I want to go with this? Under both English and American law, there can never be a piece of real estate that does not have an owner. So there's no such thing as we've talked about in personal property, the idea of abandonment and that personal property can be abandoned. However, when we talk about real estate, there is no such thing. If I die and I leave no will and I haven't sold my property, the law says it goes to my children. If I have no children, it will go to my other closest relatives. If I have no relatives at all that can be found in the world, then it would go to the state. It would go back to the sovereign, theoretically back to the king. But there has to be an owner of land at all points in time. Now, we may not necessarily know who that person is at any given moment, but somebody is there, somebody is the owner. Conditions. Moving down to the bottom of the first page here. I like to call conditions a provision in a contract or in a lease or in a deed, the occurrence or non-occurrence of which rearranges legal rights and legal obligations. An example would be, I give you a $500 deposit to purchase your car, and I agree to come back on Thursday with $3,000, the balance of the purchase price, to buy the car. If I come back on Thursday and I don't have the $3,000, but I say, here I am, it's Thursday, give me the car, I'll get you your money sometime. Even by implication, the way we set that up, it was implied that I will give you the money before I get the car. So you do not have to act. You have no legal duty to move or to act until I show up with the rest of the money. And so in that sense, a condition, I like to describe them to people as they're very much like light switches to turn on your lights at night in the house. You can stand next to the light switch, you can yell at it, you can scream at it, you can do a dance in front of it, you can say all kinds of incantations to it. Unless you actually flick the switch, the light does not go on. And conditions in deeds and in contracts work very much the same way. They lay out certain circumstances where if this happens, then. And that's very often how you can tell that something is a condition. If the wording is, if this, then that. Well, that setup is telling you that there's a condition. The if thing has to happen first. The then thing will not be required to happen at all legally until the if thing is done. So in other words, this provided that. So again, the this must happen. And if it does, then the provided part of the contract or the lease or the rental agreement or the deed will happen. If it doesn't, the person who's waiting for that action to happen can yell and scream and rant and rave and do whatever they want. But until the condition is triggered, there's no legal obligation on the other party to move or to do things. Conditions can also be negative in the sense that You can have an existing relationship, an existing set of rights, and if you fail to follow a condition, then the rights terminate. So I could have an agreement with my supplier that they're going to bring me 5 boxes of copy paper every month, and I agree to pay them $40 per box. Well, when the second month goes by and I fail to pay them, I can't call them up in the third month and say, wait a minute, I was supposed to get 4 boxes of copy paper yesterday. Where are they? At that point, they have every right to say to me, you're getting the copy paper is conditional upon your paying. You didn't pay for the last set yet. We're not sending you the next set. So therefore, I had a contract where I was expecting certain things to happen. You could say I had certain rights that I had put in place that I'll get 4 boxes of copy paper every month to run my office. However, built into that agreement was a condition that I would make monthly payments. And once I stopped making a monthly payment, then my right to receive any further service under that contract, any further goods under that contract ceases. So in that situation, instead of turning on the behavior, the condition works to terminate legal rights that already exist, to call a halt to the behavior that have been going on. You're going to, if you study contracts, you're going to run into conditions all the time, because that's one of the things that make contracts 30 pages long, is each side wants their conditions. There's a certain set of things that has to happen. And the conditions are very much like a roadmap. They help us in many situations because they basically say, particularly in complicated contracts, and we'll see this when we get into purchase and sales agreements, there are sets of conditions in just a plain normal purchase and sales agreement to buy a single family house. But they basically say, well, here it is. This will happen. And if that happens, the condition says the next thing will happen. And if the next thing happens, the conditions say the next thing will happen. And it kind of helps us walk our way through a complicated agreement by basically telling us who goes first, who goes second, who goes third, who has to go first again. So they are very useful, and you're going to run into them all the time. All right. Now, we'll deal with conditions in a minute. I want to talk about a couple of terms. As I said, there can never be a piece of real estate that does not have an owner. When all else fails and we cannot find a living, breathing human being to be the owner, then the property returns to the state. In our system of government, the state has replaced the king as the sovereign, as the basic entity upon which society is built. And the term we use is called escheat. So when we cannot find an owner of property, the property goes to the state, and the term for that is called escheat. Now, another term that we're going to run into throughout this course, and in contracts, you would run into it also, employment laws, some other areas of law you would hit it, is something called operation of law. Operation of law is an idea, it's similar to a condition in that it's a concept that says, because of the way the law is set up, upon the happening of certain events, legal rights and obligations change, and they change automatically. And no one has to set out and say, oh, wait a minute, that changed, or, oh, I got to go and make sure that they put that change in place. And sometimes people don't even know that the rights have changed, but they do. And an example of this is, we talked about one of the main rights in owning real estate is this right of perpetual inheritance. So again, if I were to have no children, I own a piece of property that's paid off, there's no liens, there's no loans on it, I hold all the rights still. I die without a will, I have no children, I have no spouse, my parents are deceased, I have no brothers and sisters. By virtue of the fact that I have passed away without a will, whoever my heirs at law are now, as of the moment of my last breath, they are the owners of that property. Now, what would happen in this situation, we would end up hiring a genealogical person, and they would go and they would try and trace the history of this family, and we might have the happy circumstance of sending a letter saying, hi, you may not realize it, but your third cousin, Jed, had 20 acres of land in northern Maine. He died, and in doing a genealogy, we find that you and your sister and 2 of your other cousins are his only heirs at law. You are his closest blood relatives, and therefore you are the owners of this piece of land. Again, that happens. The people may not even know or realize that that has happened, but because of the inheritance laws combining with the real property laws, if you die without a will, your property goes somewhere, and that happens automatically. So that your heirs at law may not even know it the moment or the day or the week or even the year that it happens, but it happens. Okay, now, there are many situations, and this was certainly more prevalent in past years than today, because in past generations, property tended not to be bought and sold as quickly as it is today. And in past generations, banks and mortgages and borrowing money were involved far less than they are today. So, as with much of the else of society, a lot of the process has become very standardized today. So you do not see a lot of the things I'm going to talk about here, but they still exist. Some people still do create them. Some of them still exist from prior times and prior deeds. And certainly anybody who's dealing in the buying and selling of real estate needs to be aware of these things so that you don't get caught unawares of a situation where you may not hold all of the rights. Now, one of the things that can happen, I have a piece of property and I'm well-to-do and I want to give it to the city for a park. We need a park in that neighborhood. And so I deed the property to the city for $1, but I put in the deed language that says, I hereby deed this to the city of Woonsocket for so long as they use this property as a public park, period. I've put a condition into the deed. Now, I could be very specific, and if I went to a lawyer and had my lawyer write the deed, he or she would probably want to make it very specific, and I could say that if the city no longer uses a property as a park, then the property would return to myself and my heirs, or the property will go to a third party, a charity or whatever. But very often, particularly in the old days, they did not use lawyers to write the deeds. They did not think about this, and even very often the lawyers didn't think it through. So we have a deed that says, I hereby deed this property to the city of Woonsocket so long as they use it as a public park. I die. Nobody thinks too much about it until somebody tells one of my nephews that, hey, your uncle used to own that property and he gave it to the city to be a park. And look at, the city's paved it over. They've made a municipal parking lot out of it. Isn't that a shame? Well, if my nephew hires a lawyer and goes to look at the title and they see in the deed to the city that there was this condition that it had to be always used as a park, and my nephew knows that I had no children, no spouse, his mother is dead, he's my only blood relative, my closest blood relative, he has the right to trigger that condition. Because basically what happened there was when I had the bundle of sticks that represent ownership of that property and I gave them to the city, I kept one back. And the one was that condition that if you don't do with the property what I'm telling you to do with it, I have the right to come and get it. Your title is gone. It can be taken away. Now, property rights do not die. They do not extinguish. And again, as long as I had an inheritable right to that property, any piece that I hold back and don't give to a third party, I still have an inheritable right to. So when I die, my nephew, who is my heir at law, now becomes the holder of that stick, of that condition, and under at least traditional real estate law, could go to the city and say, sorry, but here I am with my lawyer and a copy of the old deed that was in the record books, and you don't own the property anymore, Mr. Mayor. The city lost it because they're no longer using it as a park. Right. That is called a possibility of reverter. So what we've done is we've given ownership of the property to a third party with a condition, with the possibility that the property could revert, that it could come back to me and my heirs. And remember, it always applies not just to the person who gave that right of way, but to their heirs. Now, the courts don't like these things. They never did like these things, but they felt obligated over the centuries to enforce them because they were property rights. But very often, particularly if you're dealing with an unsophisticated purchaser of the land, this can be a result in their forfeiting their land. And if they had built improvements on it, we learned when we talked about fixtures that improvements go with the property. So if my nephew has a right to get the property back, he has a right to get it back with the municipal parking lot in place because that's now a fixture on the land and whatever else the city had put on the land. So there can be injustice and certainly non-equity involved in this type of thing. So the courts did not like it. So the courts would try whenever they could to put limitations on these conditions that would wipe out some future owner's ownership. One thing they would do is they would try and see what the language said. And if the language was just automatic, if you do not use this land as a park, my heirs and I get it back, they would call that a fee simple determinable because there was no choice. Once they didn't use the land as a park, the city lost it. However, if we needed the word, I hereby give the city this land so long as they use it as a public park, and if they fail to use it as a public park, my heirs and I have the right to reclaim it. They would call that a fee simple subject to a condition subsequent, and they would basically say the city remained the owner of the land until I or my heirs went and tried to get it back. And there are some other things that come into play there that become very important because we also have things called adverse possession rules. So if the land was a parking lot for 10 years in Rhode Island and either I or my heirs did not try to get it back, under the laws of adverse possession, that condition may have been wiped out and the city might be good to go. They might not have to give the land back. In a fee simple determinable, the loss of title is automatic. So the minute they stopped using the land as a public park, the title would go back to me and my heirs. The city might not realize it at that moment. My heirs and I might not realize it at that moment, but the title would have gone. Now, again, adverse possession will come in to help, and we'll spend a note section talking about that at length. But if we didn't take action for 10 years, then possibly the city would be wiped out. Cities would have the right to say that we didn't act quickly enough. But if the city tried to sell the property or do something else during the 10 years, any lawyer looking at that would look at it, would say, what's the present use of this? Say, oh, you don't have the right to sell anymore, Mr. Mayor, because the minute you put a municipal parking lot on that land, the city lost ownership. A right of reentry is a right to go back into the property and take possession of it if a condition is broken. An executory interest is something that exists, but the courts don't like them. And in Rhode Island, I'm not sure. Massachusetts said they're enforceable. This would be where I would say, I give the land to the city so long as they use it for a public park. And if they fail to use it as a public park, then it goes to the Audubon Society. The courts generally do not like that. They call these springing interests or shifting interests because instead of coming back to myself and my heirs, the original holders of the property, we're now trying to create a right in a third party who had never been involved in the transaction, was not part of it, and very difficult to get that type of clause enforced. A reversion is a situation where I set up the deed in such a way that if certain things happen, property is going to come back to myself and my heirs. It reverts back to us. A remainder is a situation where I give up certain rights to a piece of property. And basically I split the rights. I give some of the rights to A for A's lifetime and then to B and her heirs. In creating that situation, we're creating what's called a life estate. With a life estate, we can take, again, that bundle of sticks and we can split it. So I have, again, I'm Uncle Harry. I have a niece and a nephew, and the nephew has financial problems, never seems to be able to find a place to live, is constantly in trouble. I don't want to give him any property outright, but I want to make sure he has a roof over his head. So I put in a deed to them. I'm giving my property to Harry for life, and then to Louise, my niece. So Harry has the right to utilize the property. He has the right to live in the building, to use it, to collect rents from it. He's also responsible for taxes and insurance and repairs. And at some point, when Harry dies, it's going to go to Louise. If Louise dies first, again, we have given her the right of inheritance. Harry has no inheritance rights. What we've basically done here is we've taken the right to possess and use the property, handed it to one person, and we've taken the inheritance rights and given them to another. Even if Louise dies before Harry, it doesn't matter. It goes to her heirs or follows her will. She has the right to determine what happens. And once Harry dies, the two interests come back together in Louise and her family. But during the whole time of Harry's ownership, Louise has a definite interest. She holds the inheritance rights. If Harry were to try and sell the property, or even try and get a mortgage on the property, he'd have a very difficult time, because the minute he takes his last breath, whatever rights or interests he had in the property disappear. No one, or very few people, are going to want to take a chance on that. And therefore, the life tenant does have certain definite things they can do. However, those things are not usually considered marketable because of the fact that you could die tomorrow, and therefore, whatever interest you tried to give to me have disappeared. Now, just a summary. All of these things are called future interests. There are basically 5 of them under the law. There's a possibility of reverter, the right of entry, a reversion, a remainder, and an executory interest. All right. Having said that, a few more things here. There's a theory called merger, which means that while the rights to the property can be spread out to various different people, held by different people, that when they come back into ownership of one person, that person doesn't own separate little bundles of rights. They all come back into that bundle. So the idea here is, again, I deed the property to my nephew, Harry, for life, and then to the remainder to my niece, Louise. If they cooperate, if they get along, they can go to Fred and say to Fred, we'll sell you this property my uncle gave us. Harry will, for a certain amount of money, sign over his life estate, and I, Louise, will sign over my remainder interest, and that'll give you everything there is. Well, when it goes to Fred, we no longer say that Fred has a life estate and a remainder. We say that Fred is now the fee simple owner. He owns the whole thing. And that idea is merger. When we get into easements, we'll probably hit this again. An easement is when you let someone else use your property for a specific purpose. And if the person who owns the underlying property and the person who holds the easement becomes the same person, we say that it has all merged together and it's just ownership of the property. The easement doesn't exist any longer. Rhode Island has now done away with it, and I believe Massachusetts has too, something called the rule against perpetuities, which basically said that no interest could be created that would last for more than 21 years beyond some life in being at the moment the interest was created. And this was because the British realized fairly into the late Middle Ages that tying up land in families forever and forever and forever became very cumbersome, became very counterproductive, was not really beneficial for the economy, for society. So they basically said that if you're going to start doing things with your property, you cannot basically set up perpetual trusts that last for 1,000 years or 1,000,000 years. And so they came up with this term, which was very vague, and lawyers argued over it for 700 years, over exactly what does it mean, a life in being plus 21 years. And it was usually determined to mean that whenever the interest changed hands. So if I, in my will, left my property to my children, the rule against perpetuities would come into play the minute I died and one of them became the owner of the property. Then 21 years after his death, the property, whatever conditions, whatever restrictions I set up, would have to end. Vesting is the time when a future interest becomes the actual possessory interest. So vesting means that whatever right you were able to get by way of the condition, or whatever right you're going to get by holding the life estate, it now becomes final, it becomes permanent. A restraint on alienation. This is an attempt to determine who your property can be sold to in the long term. And people have tried this in certain ways. I will give my daughter Louise 50 acres of my land so long as she doesn't marry Harry. I will sell my property to you so long as you don't ever sell it to any of those Irishmen. These were ways that were used to keep property within certain families, keep property within certain ethnic groups, racial groups over the years. And they are basically prohibited at this point. And under federal law, under federal constitutional law, under the 14th Amendment, no court, whether it be probate, district court, state court, federal court, is allowed to enforce any restriction that has to do with race, ethnicity, religion, ethnic origin. So restraints on alienation have very much gone by the wayside, but if you're doing titles, you may still come up and find them. All right, some Rhode Island general laws that we deal with in this area. 3443, you can only give what you have. And this is a basic rule. And we may have talked about this in personal property, we may have not. But you can only give what rights you have. So if you take a piece of property thinking you are the owner, but you're actually only getting a life estate, you can turn around to somebody else and give them a deed that says you're giving them the whole thing. You never had the whole thing. All that they can get is what you get, which is, again, why we need to have a title examination done to make sure the person selling to our client actually holds all the rights. They cannot mystically create rights by just claiming on a piece of paper that they're giving them to somebody. Future estates cannot be destroyed by the action of the present interest holder. So particularly in life estate situations, which is the most common situation where we have future estates, the life tenant cannot do anything legally to stop the remainder person from becoming the owner. Possibility of reverter. In the 20th century, we realized how nasty and difficult these things could be, and we tried to limit them because they were creating title problems. So today, if any deed written after 1953, the possibility of reverter or a right of entry only lasts for 20 years from the date the deed is recorded. The right of entry or possibility of reverter, if a deed that was created prior to 1953, if a family or the heirs or somebody wanted to hold on to that right, they would have had to put a notice in the land evidence records before 1987 saying they still claim that right. If they failed to do that, then the right became unenforceable. So luckily, and now I began my career doing this in the 1970s. So for the first 15 years or so of my doing title examinations, we still had to worry about these things. But then once 1987 came, basically most of them became defunct because most people, if their ancestors had set these up 40 or 50 or 60 or 100 years ago, they didn't even know they existed. And they certainly didn't file the paperwork necessary to preserve them and carry them on into the future. Now, these limitations on conditions do not apply to leases, to gifts to the state of Rhode Island, and we can't say Providence Plantations anymore, I apologize. I still have that in my notes, I will remove that. They don't apply to gifts to charitable or religious purposes, and they don't apply to railroads, all because these are entities that usually go on longer than human lifetimes, so that when they receive a deed, they want to receive a deed that is not going to have the terms of it change 50 or 60 or even 100 years in the future. All right, I think that pretty much sums up what I want to say about note 5. We'll end here and we'll see you in the next section.